Hey everyone, Harry here to talk about the reversal of Harvey Weinstein's conviction and whether it would affect potentially Harvey Weinstein's conviction in California and possibly Donald Trump's trial in New York. And I will explain. So the New York Court of Appeals, which is the highest court in New York, it's the Supreme Court, except they call this the trial court the Supreme Court. Don't ask me why. By a 4-3 ruling, reversed Weinstein's conviction for sexual assault. And the violation that caused them to reverse it was the introduction of so-called other prior bad acts. So let me explain a little. It's an interesting rule, if a little bit arcane, but it's also really, really important in a lot of criminal prosecutions. So the basic idea is it's not fair. It's, a violation of kind of elementary fairness or even due process to convict a defendant based on her or his character. And in particular, even though it's a very strong character inference we all reach in everyday life to determine, well, they did it before, so they probably did it this time. If you had three people in front of you who you knew one of them robbed a bank and you learned that number two had previously robbed a bank, you'd all of a sudden, your confidence would shoot up that it was that guy. But that's exactly the kind of inference that many jurisdictions, New York is one of them, and the federal government is another, prohibit. And the idea is you cannot let evidence in to show conduct in conformity therewith, as the legal language goes. You can't try to show he's a bank robbing kind of guy, so he probably did it this time. He's a sexual assault kind of guy, he probably did it this time. But that principle has a whole slew of exceptions, and as a result, it tends to be a boon for prosecutors and the bane of defendants, and really for a kind of a sneaky reason, and that is that everybody understands that once the evidence is introduced that you did these prior bad things, the jury, though it will be instructed by the judge. Now, I caution you, you may not use this to show that he's got this kind of character, so he probably acted in conformity therewith. Jurors probably do it all the time. It's just such strong human nature to seize on that kind of evidence. So if the evidence of prior bad acts comes in, it's often going to be really decisive. Okay, but when does it come in? It comes in when it's for a reason other than character or propensity, as they call it in the law. Did it before, so we'll do it again. And some reasons are motive, intent, common scheme or plan, but those are the big ones. So motive or intent. So what happens in the Weinstein case in New York? He's charged with several sexual assaults, and they're just forcible sexual assaults. He's, just grossly kind of forces himself on the victims. And the trial court admitted, even though it wasn't part of the charges, the prior bad acts that were 3 assaults of other victims, and they were a sort of similar MO. So they, basically told different stories about Weinstein, getting alone with them and basically, really just sort of throwing himself on them, or, other kinds of sexual acts that were obviously non-consensual, and in a very sort of boorish way, sometimes involved with, luring them up with promises of potentially some kind of Hollywood work, etc. So that old story. What the New York Court of Appeals said was, look, the victims, as they were charged, nobody. So the trial court admitted it. This goes to intent. It goes to understanding, in the industry. Sometimes you could be confused in the film industry about whether something's intentional or not. Maybe Weinstein, we want to really show, I mean, this was an aggressive move by the prosecution that, he knew with the victims in front of him and that were charged that he was forcing themselves on. That was his intent. And you can look at these other episodes and know also that there's no way of construing them. The defense out there would have been, no, the victims consented because they were interested in film roles or whatever. And the court said, look at it, we're going to admit these other three to show. That's not what Weinstein was thinking about, and he knew it was forcible. And what the Court of Appeals, the highest court in New York, said basically was, you just didn't need him for intent. The charged acts were so, they were basically, rape or so forcible that you didn't need other acts to show Weinstein knows the difference between consensual sex and non-consensual sex, because this was plainly non-consensual sex. Or Weinstein knows the difference between when, a model or would-be actress is, wanting to get a job or actually wants to date him. And the court, again, this is the case here. It was just very clear. This is the actual charged crimes were him, plainly just, they would be rape, except they often don't involve intercourse, but, very, very much non-consensual. So that was the argument. In the Court of Appeals, and there's case law in New York that is pretty, circumspect about when something is, really qualifies under intent and care about not sort of, straying into the propensity theory. And the Court of Appeals said 4-3 that these acts were, they were really used for character and not for intent, because intent really wasn't in question in a way that these acts illuminated in any event. Okay, so that's why it's reversed. Now, let's talk about Weinstein in California, which seems pretty easy because California, there have been special controversies in sexual assault cases, and especially with kind of putting victims on trial and issues of intent and the like. And California responded with a special law that actually says you can introduce prior sexual bad acts for sexual offenses. So if someone's charged with sexual offenses, you may introduce prior sexual offenses for exactly what's banned in New York, namely, did it before, so he did it again. That's the argument. You can go, ladies and gentlemen, the jury, you saw these three women who were victimized. Same thing happened to our victim here, so he's guilty. The exact kind of inference that a judge will tell juries in New York or the federal system they cannot reach. In California, they can. So I think Weinstein is really DOA on that claim in California. One more sort of interesting point. There's the same kind of evidence in New York. It's called Molyneux evidence after the case in which it was approved. That is like it is the New York system, right? That's where Weinstein, it's like the federal, and it is the New York system. And there are other crimes and wrongs and acts that have been admitted in Donald Trump's case. For instance, the whole Kathy McDougal thing we've been talking about all week. Has been admitted and green lighted because it shows the sort of plan that a common scheme and intent to precisely not do what the defense is going to try to argue, which is, oh no, it's just an independent contract that the Inquirer wanted to make with McDougal, but rather to show the whole common scheme of trying to cover up sexual partners or victims who come out of the woodwork in order to protect his electoral prospects. So, I think that the Judge Merchan, has been pretty solid in his rulings, and they're not as sort of, I don't know if you'd call it sloppy, but more the Weinstein things were a little bit more You could see the arguments both ways. I think Merchan's been pretty solid, but I think also you can expect the Team Trump to argue that there's the same mistake been made here. And what happens if they're right, or Mullen or Merchan is given any pause? Things got to be a mistrial, because they've now spent a week as the jury hearing about Dino the doorman, hearing about McDougal, who are technically other acts, and that are introduced to show not propensity, well, the judge will instruct, but rather intent or a common scheme. So I'll bet we're going to see a little fight over that. And it's, the stakes are high in the sense that I think that it would require, if Merchan were to agree with them, A, a mistrial in this case, and B, a sort of re-sculpting. I mean, it's been a good week for the DA, mainly because they used McDougal and Pecker to sort of lay the whole scheme. I'll talk to you about that in a different tape. But if for any reason that were, not permitted, it would totally upend the whole trial. Don't see it happening, but wanted to explain the potential connection in light of the Weinstein reversal. So there you have it. Weinstein conviction reversed in New York. Don't think it won't happen, I think, in California, and don't see much purchase for Donald Trump in this case, but that doesn't mean they won't make the argument. And so stay tuned for some kind of motion, I think, early next week. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.